Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is COVID-19's impact on contractual obligations with practical pointers for businesses. Our presenters today are attorneys Eric Boughman and Skip Sell. If you'd like a copy of today's presentation, you can find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the question section of the webinar interface. And now let me turn it over to Eric and Skip. Go ahead, gentlemen.
Hello, I'm Skip Sell, and if you are a first-timer to a Forrester Boughman webinar, we welcome you. If you are a returning friend, we welcome you back. We're going to have a conversation today about the practical considerations both during and after this pandemic regarding the performance of contractual obligations. And our format today is to have a conversation between us and with your input. First, an introduction about us.
Hi, everybody. My name is Eric Boughman. I am a founding partner of the firm, Forrester Boughman. We're located in Central Florida. If you're joining us from outside of Florida, welcome. My practice generally involves dealing with businesses primarily in the healthcare and technology arena. I do a lot of healthcare work and have clients across the board who have been affected by the ongoing issues with coronavirus, COVID-19. Our firm is a boutique firm with 10 lawyers that serves a variety of industries, all in the corporate tax. We do some personal asset protection and estate planning work. And essentially, we are a number of lawyers who've been practicing for several years. Some of us have come from other firms and found a home here at Forrester Boughman. I'm joined and happy to be joined today by Skip, who you've met. Skip is a longtime Central Florida lawyer and litigator. Skip has litigated virtually any issue across the spectrum for businesses, large and small, hospitals, healthcare groups, individuals, and brings a wealth of knowledge and experience to our team and to the issues that we're going to talk about today. And Skip, anything else to add?
The only thing I would add is I would encourage all of you to take a look at some of the writings that Eric has done in both healthcare and technology. He's a prominent writer in those fields. And you can also check our website, which has other past webinars that we've done regarding the pandemic, as well as other issues that may be of importance to you. We welcome you to the conversation today.
All right, take a quick look at our agenda and the issues that we're going to cover. Don't be overwhelmed by the length of the agenda. What the topics are generally going to break down into what we look at when we're looking at contract enforceability during the crisis that we're all going through right now. And we're going to walk you through the steps, talk about some practical considerations, and use a few examples, some prior history and case law, and try and give you some direction on how to deal with a lot of the questions that I've been fielding since this all started, and that I anticipate just by virtue of the comments that I've seen in articles and other webinars, that this is an issue that's impacting a lot of people, and we anticipate that it'll continue for a while. So as we jump into the material, first thing is a little bit of background. I'll let Skip turn it back over to him for that.
Well, we all know that times are uncertain and the news is not always good, so we're not going to dwell on that. We know you're all paying attention and trying to figure out what's the best and safest thing for your family and for your business and your friends and yourself. So we know what the issues out there. We know that there's high unemployment. We think we're creeping into a recession, could be a depression. We're all dealing with the stay-at-home orders and how to deal with our employees, our contracts. There are supply chain issues that we see with the pandemic and with our own businesses. So what we're going to try and do is talk about maybe some little good news and to look historically back at how other businesses and courts and lawyers have dealt with legal contractual issues in uncertain times. And we've gone back and we've looked at what happened with the Spanish flu in 1918. There's other historical events in Florida. We have hurricanes. How do people deal with that? We've had the Ebola epidemic, and we've had 9/11. So there are instances in the past where we can draw upon and try and help you come up with a game plan for going forward in the future.
All right, so let's talk about how we do that. So the first question that we have presented to us as lawyers, or the first question maybe some of our clients or colleagues have is, what are the impacts to our business? What are the impacts to our ability to survive? What are the requirements for us to continue to perform? If you have a contract to rent space and your business is closed down and you can't get into space, do you need to, how does that work? Do you still have to pay rent? Do you still have to pay on loan obligations? If you have a performance contract, if you were supposed to host an event and that was occurring during the time of the shutdown, and it made the event essentially legally impossible, what are the implications of that? Who has the risk of the loss because that event did not take place, especially if you've got deposits in place? And let's say if you're in the entertainment industry and you're a promoter and you've hired several other key support pieces, how does that all play out? And we're going to walk through, what the analysis looks like. And really the first thing is, we're going to take a look at the contract itself, and we're going to see what type of language is in the contract that speaks to performance and speaks to outs. Skip will give you an overview of force majeure clauses. And Skip, force majeure is?
That it's a contractual clause, and the idea is that you are allocating the risk. You're trying to consensually, through a contract, allocate who's going to be responsible when some act occurs that is not foreseeable. And force majeure is French, and that means superior strength. Superior strength took over what your obligations were in the contract.
All right.
But if you don't have a contract, then you can look to other legal concepts.
And so without a contract, and the first place we always want to start any business transaction, the lawyers are always going to ask you, what's the agreement? What's your deal? What does the agreement you have in place say? If you have either written or verbal, if you have a written contract, we're going to want to see the contract. And if you're advising clients, that's the first thing you're going to do is you're going to look to the contract, see what the language is, and see, in this particular instance, we're looking for contingencies and performance requirements and performance outs, and that's why Skip mentions the force majeure clause. If you don't have a force majeure clause in your contract, or if you have a weak force majeure clause in your contract, then we look to common law. And common law essentially just means that it's not in a statute, it's not in a contract. So what other potential remedies do we have to deal with situations where performance has become difficult, impracticable, or impossible, or is in some way frustrated?
For the non-lawyers that are with us today, what the common law means is that there have been other litigations between parties, and a trial court or a jury makes a decision applying the law to the facts to the law, and then whatever that decision is, it's appealed, and an appellate court makes a ruling about whether the trial court and the jury were correct and the parties were correct in their legal positions, and that creates case law. And the case law then we can look at and see how that case law applies to our current situation. So when we talk about going back and looking at the epidemic of the Spanish flu in 1918, we're looking at those cases and those parties, what they argued, what they tried, what was successful and what wasn't, and whether we can apply those principles to what's happening today.
Excellent explanation. And when we look to common law, the primary provisions or primary aspects that we're looking at are concepts that are often confused, but I'll try to give you some examples as we go through this. One of them is frustration of purpose. What was the purpose of the contract, and has that been frustrated, or is that purpose now gone? We'll talk about that a little bit more. The other is impossibility of performance. We hear that term thrown around a lot, impossibility of performance under a contract, or sometimes impracticability. We're going to talk about what that means. And as an overview on this slide, before we jump deeper into force majeure, I want everybody to keep some overarching concepts in mind. And I wrote down these notes just to remind myself that this law, there's a lot of detail. The cases become very fact specific when we look at a situation where, do I have to perform? Do I have an out? What are my remedies? What can I do? But when you're looking at whether there's a force majeure clause or whether you're dealing with common law, you need to understand that foreseeability and control are overarching concepts through all of what we're going to talk about today. Control in that if there's a reason the contract can't be performed, it has to be something that's outside of the party's control. Foreseeability becomes important, and I think it's really emphasized in the difference between force majeure contract clauses and the common law, in that in a contract, as long as it's not illegal, you can bargain for almost anything. So you can bargain for things like price increases, labor shortages, supply chain shortages, bad weather. Whereas at the common law level, a price increase is not going to get you out of a contract. Courts generally, as a general rule in Florida, and I've looked at this issue and litigated this issue and looked at other jurisdictions, courts generally are not sympathetic to an argument that it became too expensive for a party to perform, even if the party is going to lose money in its performance, or that it's, that you have some type of financial situation that's making performance impossible. Whereas when you've negotiated for a provision, your negotiated force majeure contract clauses can be much broader, because these are things that you might anticipate. So that's the foreseeability issue. If it's foreseeable, you're not going to get out generally for impossibility or frustration of purpose. But if it's foreseeable, when you've negotiated these, you may want to look and say, well, this might happen, and I want to make sure I have an out. So keeping those concepts in mind, and by the, another thing I thought of as I was going through this, and I've been writing contracts recently. I just was doing one for, it was a medical technology agreement, and actually that arose, the idea I think arose out of this COVID. And as I was looking at the force majeure language, of course, every attorney now is looking for pandemic, epidemic, national emergency, and you're making sure that's in their virus. I've seen contracts where it's in, and I've seen some where it's not. It's not too late. And the reason I say it's not too late, if you're drafting, if you're an attorney and you're drafting, make sure that stuff is in there, because this might seem like a once in a lifetime situation now, and maybe we get, if you don't have pandemic, you get it into something like a contract provision says act of God. But if we have a round 2 of this, and a contract was drafted in May, and we're looking at a force majeure provision next spring, and that force majeure provision drafted right now doesn't have epidemic, I think courts would be much less sympathetic, because they're going to say, hey, that was foreseeable that you'd have an epidemic, you should have written it in. Whereas when we're looking at contracts now that were drafted a year ago, it may be enough that we have act of God or national emergency, or there's some other language we can squeeze it in under. So,
I just want to point out a couple of things that goes off slide and goes off outline, but I think is important for our audience to recognize. The first is that what Eric is describing is why the combination of a fighter and a writer as a legal advisor makes so much sense. Because Eric's background as a fighter is in litigation, and he goes to court, and he argues about what the contracts are, what they say, and tries to get to the position where it's in the best interest of the client. But because of that experience, in writing the contract before it's fought, you can take out some of those contingencies, you can put things in, you can make it stronger for the client, which takes me to the second point I wanted to bring up about what you said, and that is proactive. Because what Eric was suggesting is something that you may be able to do right now proactively to help yourself. Being in control of your contract and what it says is important, because you'd rather have that be the deciding factor than a judge or a jury, because the common law concepts we're talking about are affirmative defenses. And that's the other thing I wanted to talk about just briefly for the non-lawyers. When you bring up impossibility of performance or frustration of purpose, it's an affirmative defense. Somebody's suing you because you breached the contract because you couldn't pay. And you bring up and say, no, wait a minute. There's a reason I didn't pay. And I didn't pay because of this pandemic. That's the cause of my non-payment.
affirmative defenses are yeah buts. Yeah, but.
Yeah, that's exactly right. They're legal excuses or justifications where the law takes as true that the contract's breached and that there are damages, but the affirmative defense says, oh ha, so what? I've got a legal excuse or justification for not paying.
Good point. And so now as we talk about force majeure, and before we get into the elements, just an overview, and I'll cover this and then I'll talk about the elements in more detail. But as I said, this is something that you write into the contract or you don't. And that has an influence because you can generally cover issues that are foreseeable in a force majeure provision. Something else to keep in mind is that those provisions, again, unless they're illegal, then you can negotiate for almost anything. And there are some times when you can get too broad, and we may talk about a couple examples of where that's happened. And this is a provision that's in the contract that attempts to release the parties from their obligations, and it's generally going to be circumstances that are beyond the party's control. Even if you negotiate for a provision that says, well, if there's labor shortages, it's not going to fly if you furlough your workforce and say I have a labor shortage. So it's got to be something that you don't have control over. And so from a broad perspective, as we talk about a force majeure contract and a contract provision, now let's talk about some of the elements, and we'll list those out and then have Skip do a little discussion. So Skip, I'll let you go through these.
The way I'd like to do this, even though it's on the slide, is I want to talk about a recent case that I think defines what force majeure is better than I can explain it.
Okay.
And then I want to talk about the events. What is a force majeure event? And then what's some of the common triggering things? And we can do this as we walk through, because that would cover what are potential disruptions. And the case I'm talking about is just from last year, and it's from the Honorable Donald Middlebrooks in the Southern District of Florida. And I happen to think he's a good judge. I worked with him almost 40 years ago when I was in law school, before he was appointed to the bench. And what Judge Middlebrooks described in this opinion from last year are three important points that you have to know for force majeure. First, the definition. It's a contractual provision that allocates the risk of loss if performance becomes impossible or impracticable, especially as a result of an event or effect that the parties could not have anticipated or controlled. The other two things that he said in this opinion from last year is that they're very narrowly construed. That means they're construed to not find it effective. You've got to look very closely at exactly what the contract says. And he says that they will generally only excuse a party's non-performance if the event that caused the party's non-performance is specifically defined. And he means in the contract. And that's what Eric was talking about. You always start with what the contract says. And then the last thing he says is that the enforcement of these clauses and cases around it is limited in precedent. There's just not a lot of cases out there, despite the fact that we've had pandemics before and hurricanes before. But those are the broad general things. So what potential disruptions are covered? Well, you start with what are force majeure events? So like Eric was talking about, like Judge Middlebrooks talked about, not reasonably foreseeable. It's beyond your control. It materially affects your obligation to perform the contractual obligations, and it's the event that causes the inability to perform.
So you're bringing up the point that it's not going to be a minor issue. It's got to, it's the issue of how much damage. It's got to be substantial. It has to impact the value of the contract to the value of the performance.
It has to be substantial. But in that decision I was just talking about, Judge Middlebrooks also pointed out under Florida law, you don't have to prove that it made performance impossible, which could be different from the common law you're going to be talking about before. This is different. This is consensual. It's contractual. The parties say what event, and they can say what is excused by the event. So what can be these events? Acts of God, strikes, lockouts, industrial disturbances, wars, blockades, riots, epidemics or pandemics like we see now, restrictions by governmental authority like the stay-at-home orders, unusual transportation delays. Those are the types of events. And then there's types of contracts. And it really can be in any contract.
And that's actually one of the questions that we have up here. Somebody has given us a question. By the way, if you have questions, you can type them in. One of our questions is, what type of contracts do force majeure provisions appear in?
Leases, real estate, sale agreements, construction agreements, prepaid events and services. Central Florida is big in the service industry. You have weddings, you have cruises. But the real question is the contract you're dealing with, does it have a force majeure clause? Because if it doesn't, we're going to flip into the common law legal concepts that you're going to talk about in a second. But like any contract, you can put this provision in when you're negotiating a contract. It's consensual.
Now, what about, you talked about how they were narrowly construed, and you talked about all the types of language you can put in a force majeure provision. What's the court's view on catch-all phrases, including but not limited to? How is that going? If your contract says it's the seller may or the person providing services may terminate the agreement for the following reasons: it's acts of God, acts of government, epidemic, all these other things, including but not limited to these items. Is that the type of language that is going to be helpful, or what do the cases say?
The cases say that you're better off having specificity, and you can see how this comes up not just in contract preparation, but also in business interruption insurance policies, right? After 9/11 came, you would see being put in the contracts terrorist attacks, or insurance policies excluded from coverage terrorist attacks. We had SARS not too long ago, and even though it didn't reach these proportions, or Ebola, you can see that there are now contracts and insurance policies talking about pandemics and epidemics and viruses. You can see some where people say some problem with that. But almost all of them, here's the interesting thing, have act of God, which is, in my mind, a pretty all-encompassing catchphrase. And it's in there, bargained for by the parties. And I think that is the catchphrase. And there are cases that say other things that aren't listed are acts of God.
Okay.
Is that?
Yeah, that's helpful, I think, for our party there. And I want to make sure we cover, because we're going to come back to some practical considerations. But when we're talking about act of God, right now, does the epidemic, do we have authority? And I think we have the old cases from the Spanish flu that were all over the board. But I would be asking, if I was looking at this, is the epidemic covered as an act of God? And just recently, I looked right before we did this webinar, there's a couple opinions that have actually come out in 2020 that have speak to this issue. Essentially, there's a Pennsylvania case, and then Florida had a case about a week ago. It wasn't a force majeure provision, but it was the court taking a look at the authority of government for the government shutdown here in Florida. And
the governor's
issue came up in Pennsylvania.
At home order.
And the courts seem to acknowledge that this pandemic is an unprecedented event that qualifies as an act of God. So if you have an act of God provision, one thing I would probably be doing if I was trying to argue that the this pandemic issue was covered under that, is I would go to those cases and say, look, courts in other contexts have already determined that we have an act of God that has caused disruptions and shutdown, and then I would look to see if I had a force majeure provision that I could hang my hat on that act of God language if I didn't have pandemic language.
1944 case from the Supreme Court of Florida. There's a hurricane that went through Tallahassee, and the power company wasn't able to provide service to the city. The city then decided they weren't going to pay for service that they didn't receive and tried to deduct it out. The power company sued them, and the court said the hurricane was an act of God, and it was a legal justification for non-delivery of the electrical service under the contract.
Okay.
There you go.
So, and by the way, as we mentioned some of the cases that we talk about for the lawyers out there, anybody else who's interested, if you want the names of these cases or any sites, let us know. Shoot us an email. We'll give you the contact information to reach us at the end, and we'll make sure you get them. It's interesting you bring up hurricane, because you see that in a lot. You'll see hurricane, tornado, bad weather in contracts, and that's, I think, a good example of where it becomes fact specific, because of and you look at causation issues. I've seen where, if a hurricane comes through Central Florida and wipes everything out, there's no power and you can't perform, that's one thing. But if you're in Central Florida and there's a hurricane that hits South Florida, and we weren't really impacted here in Central Florida. And that hurricane was 2 months ago. Unless you may have a supply chain issue, you may have some other difficulties because of the hurricane, but I think you have a harder time fitting your facts into a situation where that hurricane really caused enough, and back to one of the elements here, enough disruption in performance where that hurricane really was a cause of that, and you probably can't hang your hat on it. So hurricanes, I think, give a good example of where it becomes, it's a very fact-intensive issue. So when we're talking about the pandemic, to what degree are you affected? And this brings us into another issue on our slide here. Performance, non-performance, or underperformance. Does the pandemic make performance impossible? Well, to use an interesting example, with everything being closed recently, if you had a contract to get your hair done at the salon a month ago, that was impossible. So you couldn't perform. But there's a lot of other instances where performance isn't made impossible by what's going on. But and maybe it only impacts you. Take it, for instance, a long-term lease, a 5-year lease. Well, you may only have 2 or 3 months that are really affected by the pandemic. The rest of that lease is not going to be affected, especially if you're in year 4 or year 5 versus the first couple months of the lease. So again, case by case, and take a look at the facts of your situation and ask the question. And a common sense question is, am I really affected by this? Or is the other side, who's trying to rely on a force majeure provision, are they really affected by what's going on right now? And to what degree does that cause that? Does the pandemic cause that issue?
Going back to the Spanish flu, in 1918, there was a case, I think it was actually decided 2 years later. Spanish flu was in 1918, and it was a soap company. And the soap company had a contract to provide soap. And in that case, the city put a stay-at-home order, and they had to close the factory. And they were supposed to have delivered, I apologize, they were supposed to have delivered the soap by the end of 2018, and they couldn't do it. And they delivered it right after. And the buyer of the soap said, I'm not going to pay for it because you didn't deliver it. And I don't have to pay for it because of the pandemic. And the court said no.
The court agreed that they didn't have to pay for it, or the court denied that?
It did not excuse the buyer for non-payment because of the Spanish flu.
Because it was a delay.
Because of the delay. They got what they were supposed to get, but it was slightly delayed.
So that's another good example of something we might look at, a historical case, and what we might look at right now. And I saved this question. There's another one that popped up here, and I'm tracking the questions. I wrote it down. And somebody asked, why not just include a laundry list in the force majeure provision? And I have seen that.
It's a great question.
Included. For one, it's bargained for. So if you see a force majeure provision that's a page long in a contract, and you're looking at a contract, that should call your attention to that provision anyway. Like, how many outs does the person on the other side, are they giving themselves? But it can come back to bite you, and I just want people to be aware of that if you're looking at this from a drafting standpoint, or in a contract performance standpoint. And this has to do with overbroad force majeure clauses.
Can you explain why it comes back to bite them? Because I think I know where you're going.
I can, yeah. So the best way to do it is use an example. So in the last real estate downturn, 2000, I think it started in 06, in 2010, here in Central Florida, and I was doing a lot of work with folks who had real estate investments, all areas of everything. Real estate was in everything, and it still is. It's a big part of our Central Florida economy. A lot of people had put deposit money down on houses and condominiums, essentially for speculation. And I represented, one medical practice owner who had picked up several properties. He was building like a little monopoly empire of houses and condos, and then the market dropped out. And some of these deposits, they started out as 10 or 20,000, but they were up to like 200,000 for deposits for condos downtown. The market dropped out, people couldn't flip the units, and they were looking for ways out. Well, in a lot of these contracts, there was some language in a lot of these real estate contracts that would say that no matter what, the developer of this new construction was committed to complete construction and deliver the unit within 2 years. And nobody really understood why that language was in there. But if you understand why it was there, it opens the door to a legal argument. And the language was there because in order to be excluded from certain disclosure requirements for property under construction under the Interstate Land Sales Act, under ILSA, you could be excluded from disclosure requirements, and you have to do an offering circular and so forth, similar to like a stock offering. If you were a developer, you could, one of the exclusions that was commonly relied upon was you had to commit unconditionally to deliver the unit within 2 years.
Mm-hmm.
And so all the developers that didn't want to comply with ILSA put that language in their contract. And then we started to look at the contracts, what type of outs the developers had. And there was a case, was Harvey v. Lake Buena Vista. There was another one, Stein, I forget the whole case, but a few of these, and I actually used this argument myself with success, that the force majeure provision was too broad. And because the seller, developer, had included a whole bunch of extra language, supply chain shortages, labor shortages, price increases, et cetera, as a basis to terminate the contract, we argued that the contract did not unconditionally require the developer to complete construction within 2 years. There was a whole bunch of conditions on it. And because the developer failed to do so, they were selling properties that were subject to ILSA, and they didn't make proper disclosures, and the buyer had a right to rescind. And that argument was successful. So it's, again, you can include that language in there, but you want to make sure that you don't bite yourself with a illusory, that's the term that's used legally, is that it's that the obligation, you have so many outs that the obligation on the other side becomes illusory, and you don't really have an enforceable contract.
There's another side of that too, in that, and it's similar, but if you list a laundry list and whatever the event is that you're relying upon is not in that long laundry list, it can be interpreted to mean that everything, because it's a laundry list, that you wanted to be in there was included.
That's right.
And if it wasn't included, you intentionally excluded it because you had the right to put it in when you did the negotiation. That's the other problem with doing the laundry list. And I think you're also right. And the takeaway, I think, for our listeners is the language in your contract is really important. And you need to have it carefully looked at by your legal advisor, because that's the first thing that the court is going to look at, and your lawyer is going to look at, and the other side's lawyer is going to look at to see about its enforceability.
And there's arguments that can be made both ways.
And that's what we found.
Yeah.
When we went back, and just one more quick thing before we switch into the common law, we went back and looked at the cases for the Spanish flu, and that's what we found. The courts were going both ways. And in one case, I remember the school district was trying to get out of paying the teachers. They had a contract. And the school district said, hey, wait a minute, the schools are closed. We don't have to perform. And the court came back and said, if everybody knew that a pandemic could happen, you don't know when, you don't know which one, could, if you wanted to put that in your contract when you were bargaining with the teachers union or whatever they had back then, you should have, you didn't. You have to pay the teachers.
That's an example of, I think sometimes courts are going to favor, or particular judges are going to favor one position or another. It leads to a little bit of forum shopping. But yeah, I think the big picture takeaway is don't assume just based on your language that you're in or you're out. Take a close look at it, give it a good analysis, and do a little bit of due diligence with respect to language in your particular situation. If you can find a similar situation and you can tie it to that situation by analogy, you can make a successful argument one way or the other. So let's talk about, if we don't have a force majeure provision, I'm just double checking for my questions here. Another one popped up, and I'm saving it. So I know you've got a question pending there, and I'm saving that because I'm going to talk about it here in a minute. So if there's no force majeure provision, now we're looking at common law. So what are my outs if I'm under a contractual obligation? And the first and most common is that it's impossible for me to perform. And it has to be, essentially something, a situation that makes it objectively impossible. A perfect example of that would be a concert that was scheduled for Orlando for the month of April when everything was closed, and there was no concerts because it was illegal. It was objectively impossible for the parties to perform that agreement.
What about this stuff? What if now the things, You had the stay-at-home orders. What I'm trying to figure out is, I get if it's impossible. What if it's just difficult? What if you can perform, but it's going to cost more money? What if you can perform and it's going to take more time?
So we may get into frustration issues, or we may, if it's just that performance is rendered more difficult and more expensive, the courts are very unsympathetic to a party having to bear additional costs to perform. In general, that's the general gist of the cases when you read them. If your argument is, hey, I can't perform because I can't afford it, and there's an example from not too long ago, and the case involved, I think they're out of business now, it was TWA Airlines, I believe, during the first Gulf War, and because of the war going on and oil shortages and price increases, TWA had made an argument that their performance was rendered essentially impossible or financially impracticable because of the war going on. They tried to rely on the war, and the court was not sympathetic to that argument. I think we will see the same thing here. If you had a duty to perform and you could, and it's simply more difficult now. Perfect example is loan performance, lease performance. If you have a lease, services, if services have already been rendered, by the way, money is rarely going to get you out of it. If you've already received goods or services and now you want to get out of payment or a payment plan, that's not going to work. And parties, by the way, can cover themselves in other ways, and we'll talk about that, insurance and so forth. But good question. Yeah, it's really got to be something that's impossible for a party to perform. And it's got to be something that's not, again, it's not foreseeable, like force majeure. You have some other objective issues that the courts look at. The foreseeability issue here, something where you didn't have the facts available to know that performance would be impossible. Costs, by the way, hurricanes. Hurricane comes through Central Florida. That's foreseeable. A hurricane hits, New Smyrna Beach in the middle of July and takes out power for 2 weeks. Not so foreseeable. But hurricanes rolling through the state that might make transportation more difficult, create some delays, entirely foreseeable.
So I'm trying to put my arms around this for people that aren't lawyers. People have been talking about a virus like this could be in the future for a long time, and we have coronaviruses every year, and we've had pandemics throughout the history. Is it that a pandemic's foreseeable, or is it the particular pandemic or the hurricane? Because every year we have a hurricane.
We've talked about this before, and Skip and I have gone back and forth on this issue of, to what degree is the pandemic? So anybody, if you watch TED Talks, the Bill Gates did a talk on the possibility of a pandemic several years ago and how unprepared we were. There's been back and forth. It's become a political issue that has gone back and forth. Who's to blame for this and how much was it foreseeable? In my view, we have not had a shutdown like this at a national level with the level of fear and the zeitgeist surrounding what's going on, and government becoming involved in creating shutdowns for over 100 years, since the 1918 Spanish flu. And so I would suggest that this pandemic, the pandemic was foreseeable, but the issues that it created were not foreseeable. Again, bad weather is foreseeable. Rain is foreseeable in Florida. Something, a funnel cloud dropping down and wiping out your house is not foreseeable. And I think this is more analogous to the funnel cloud. And I think that's supported by the recent decisions. That's why I mentioned the ones, we talked about Pennsylvania and Florida, where, again, different context, but the courts have already looked at this and said, look, this is like an act of God. This is not something that happens commonly. But you should note that, again, courts want to enforce contracts. If you have a contract provision, that's what makes force majeure contract provision so useful, is if your contract falls squarely within a force majeure provision, then you've got a great argument. If you fall squarely within a certain contingency, that the weather is going to be a certain way, or that some other things are going to happen and are not, or certain assumption that the facility is going to be open and it's not, you're in very good shape. Otherwise, as noted here on the slides, this is a defense, and it's generally brought as a defense to a contract performance. I did not perform, but I had a reason why. And courts generally will apply this very sparingly and only after a very fact-specific analysis. As an aside, for the attorneys out there, or if you're not sure of your requirement to perform, there's two concepts that I want to introduce you to quickly here. And this came up as a question. Somebody lodged a question a little bit earlier and asked, what if I think my counterparty is not going to perform? Well, one, you can file an action for declaratory relief. There's a declaratory relief statute in Florida. I've done that in all types of contexts. Right now I'm dealing with a medical payer dispute with an insurance company, and one potential action there is to seek declaratory relief that we're reading the contract properly and the other side is not. If you think you have an impossibility issue, but you're not sure, and you've raised this with the other side, and your negotiations have been unsuccessful, you can bring it as an offensive claim, and you say, look, I have this contract, but we don't think that it's enforceable. I don't think I have to show up and perform on a date certain because of this event, and ask for declaratory relief and use it as an offensive weapon. But it's still a defense to performance under the contract. The other concept is this notion of anticipatory repudiation. Fancy term that essentially just means, if you break it down, I'm anticipating that the other side isn't going to perform, anticipatory repudiation. And there's some steps that you can take. Really, a lot of it boils down to communication. If you think that the other side, if this is all going on, and you say, well, my counterparty can deliver X or can do whatever they're supposed to do, but I don't know if they're going to show up. You can give notice to your counterparty and ask, give them the reasons why you think you have doubts about their performance. And usually there has to be something else other than just third-party events, something that they've done, they're not communicating with you, they've hemmed and hawed over something, and you can send a notice in writing and ask them to reaffirm their obligation to perform. And if they don't do that, you now may have a declaratory action for anticipatory repudiation. I think the other side's not going to perform, and I don't want to wait for that to happen. I want to step in and have the court do something now. So, different ways you can handle these. They all deal with the impossibility issue. Mm-hmm. Now, frustration of purpose and impracticability. Impracticability is kind of like impossibility, but not as much. It's raised in the financial context. But one court said it best, and that's that in order for an act to be deemed impracticable, it's got to rise to the level of being financially senseless. So if you keep, is this financially senseless to continue to perform? Can I require somebody to show up and put on a concert? I keep going back to the concert things. I've talked to a couple people about this. At Amway, when I know nobody's going to be there, I know no tickets are going to, nobody's going to walk in the door. Can I still require a performer to show up and set up lights and do the whole thing and have the promoter go forward when I know it, even though maybe they can get permission to enter the building and it's not impossible, it's completely, one, it's financially impracticable because the promoter who might be getting paid on part of the door, there's no reason for them to show up. Nobody's going to buy a ticket. And then the other concept is this frustration of purpose. And this gets it's a little bit of a confusion with impossibility, but I'm going to give you some examples that's going to break it down. So, the elements of frustration. The parties, and I'm watching our time here, parties knew the purpose of the contract, and that purpose of the contract was frustrated because of an unforeseeable change in events. Again, this is something that the courts apply sparingly, and like impossibility, very fact specific. So let me give you an example. Let's stay I'm on this concert thing today. So Amway Arena, I have a contract as a vendor to show up and sell beer on the night that there's going to be an event. And now the arena is closed. Can I sue the arena for not letting me in? I'm probably going to lose that because it's impossible for performance to occur. But what if I have a contract to sell beer outside on the corner at a vendor stand, and I've already got my my temporary permit to do so, and I can stand outside, and there's nothing restricting me from standing outside? My performance is not rendered impossible, especially now as things start to open up. I could show up down there and sell some beer and whatever, snacks, hot dogs, if you eat that type of thing. You shouldn't, but I could do things like that, but it doesn't make any sense to do it. In that case, if I'm the vendor and whoever owns that land, whoever I sign a lease with, whether it's Amway or somebody else, wants to hold my feet to the fire, I would raise the argument of frustration. Look, the whole reason we were doing this is because there was going to be a big event going on inside. And now that that event is not happening, even though it's not impossible for me to perform, the whole purpose of our contract has been frustrated. And that's the legal defense.
Well, can I, thinking about another example.
Sure.
Let's say you're a restaurant in downtown Orlando and you've got a stay-at-home order, and well, let's say stay-at-home and restaurants are closed.
Okay.
But you can just do takeout or a curbside pickup. A lot of people were doing that. But there's no way that that's going to give you enough money to pay your AC and your rent and or your other things.
Look, we're seeing that in all kinds of contexts.
Does
right?
it come up?
We've seen it now. We're seeing it where restaurants, some are doing well because of takeout, and some are really struggling because they're sit down. They're more of a fine dining. I mentioned something like a Ruth's Chris. They've been in the news. People don't get takeout generally from there. We see it. I did this webinar about a month and a half ago on the new payment methods and modes for telehealth. So a lot of the healthcare industry has been very busy, but a lot are not because they're not seeing patients. Medicare, CMS has broadened, and a lot of the private payer insurance companies have broadened the spectrum of payment options through telehealth and broaden the modes of communication so that you can do a telehealth appointment like I did yesterday through FaceTime or some other video mechanism. In that respect, you might say, well, you can still open, you can still operate, but what about dentists? Oddly, in the telehealth statute in Florida, you can perform all types of medical and healthcare services such as dentistry, acupuncture, I think is listed in there. It's a laundry list of things that technically where you can do it through telehealth, but it's not practical to do it. And those, you're looking at two totally different circumstances. If you have a physician who can keep their practice going at maybe 60% of revenues for 2 or 3 months, are they going to have an argument? Maybe their performance, somewhere, if they have metrics they have to perform by, or payment obligations, are they going to have an argument that they can rely on because of impossibility or frustration? And I think it really rises to a level of, to what degree is there a cause and effect relationship, and what's the impact?
What my takeaway on that is, for all these, whether it's force majeure or any of the common law, it's really fact specific about your situation.
Because we got a couple minutes, and we'll give you some practical considerations, because this gets to be a tough concept. So let's use another example. Let's say that I was going to put up a billboard at, for a plastic surgery billboard at 528 down in South Orlando, right up by near Disney. And I was going to light it up at night, and I'd sign a contract that says I'm going to put this billboard up, I'm going to put all kinds of lights on it, and it's in order to generate the traffic that's coming through, and I was going to run it for 3 months because of some special event that was supposed to occur at Disney. It could be the Olympics, it could be Wide World of Sports. And what I'm doing is I'm taking facts and trying to put them into today's event. There was a very similar situation, a billboard during World War II that was supposed to be a lighted billboard. This is an actual case that occurred. And the issue that came up was, well, we can't turn the lights on the billboard because of the government restrictions during World War II. So by today's analogy, you might say, well, there was supposed to be an event at Disney, and that event's not going to occur. So the purpose for which I was going to put the billboard up is now, it's not enough for me to put the billboard up if nobody's coming by. So what type of argument do I have that I might not have to buy the billboard or lease the billboard for that time? Well, one might be, it's not really an impossibility argument, but if you take the World War II example, if I was paying for a lighted billboard at night, and it was going to be a digital lighted billboard, and now there was some type of government restriction that says we can't light it up, now we've got a possibility. But if I was just paying for a lighted billboard that was going to be there all the time, because I can use it during the day, I don't really have an impossibility argument. But if it's for a special event, like a Disney event, maybe I have a frustration argument if both parties were aware of it. Now let's say I got the billboard. I didn't tell the billboard owner why I was getting a billboard. I just leased it out for those, for this period of time. And I hired a third party to put lights on. And now there's some law that says I can't put the lights on at night. Can I get out of my contract with the billboard owner? And the answer is going to be no, because the billboard owner it had no knowledge of my purpose of getting the billboard. They just leased me the billboard. So one of the elements for impossibility and frustration is both parties have to understand what the purpose of the contract was. And then the question is foreseeability. So if the counterparty was not, if the owner is not knowledgeable about my purpose for the billboard, I'm not going to get out of that contract. But what if I get the billboard and now I'm supposed to pay somebody to come put lights on, but now it's illegal for them to put the lights on? Or because of the shutdown, because of pandemic, they can't go outside and do any work around the billboard because their business has been closed. Now what happens? Well, now I've got a billboard that I might have to pay for. I have no impossibility argument because the landlord didn't know why I was getting it. But on the other side, I've got this obligation with somebody to install lights that maybe I can get out of due to a frustration type argument or an impossibility argument, or maybe the other side can get out of it. They don't want to perform because they could say, well, my performance has been made illegal due to the pandemic. Mm-hmm. So you can see that you could take the same facts and twist something a little bit, and you now have a different defense or a different issue that pops up. We could keep doing that. I kind of drew out a couple examples, but I want to jump in, Skip, to, I want to give folks some practical takeaways here. And so here's the first one.
Proactive.
Be proactive. Get, and we mentioned insurance earlier.
There's some interesting, if it's okay. I heard some reporting yesterday that was interesting about the insurance. It was reporting about litigation that is starting for business interruption policies. And one of the things you want to do is check to see if you have a policy, and check if those insurance policies are interesting because they give coverage and then they take away coverage. So you've got to look at the entire policy. But the reporting yesterday was that about 1/3 of businesses have that type of coverage, and they are getting immediate denials of claims. And so far, the denials are based upon there's no damage to property. And the policies are written for damage to property, at least for those policies that were being reported. So I think there's going to be an uptick in litigation pretty quickly.
That's an issue that permeates every major event, and I spent several years with one of my dental clients years back arguing over insurance coverage when the business was shut down for 3 months, and one of the issues was the availability of business interruption insurance because is this a flood or a sewer backup and what type of damage. So get on the horn with your insurance agent, take a look at the stuff that you have yourself, and contact, if you're not an attorney, contact your attorney, contact one of us. Don't wait to address that. A few other issues here is, I'll make sure on the slide there. Okay.
All of these, Eric,
review the contracts.
Are what we're talking about for being proactive. Get your documents, review them, get your advisors, figure out your game plan, figure out how you're going to be impacted, how your ability to perform, the people that you're counting on to perform. And also being proactive means having discussions. If you see the issues coming up, it's probably better not to wait for it to explode and to be proactive to see what you can do together collaboratively, because everybody's in this together.
Yeah, I encourage all the time when I'm talking to people, communication between parties on both sides. This is really a fluid issue in my view right now, because we don't know what's going to happen in the next 2, 3, 6 months from now.
There could be a second wave, a second shutdown, a third wave, and a third shutdown. We don't know.
Just that possibility is keeping people at home. I'm thinking of some of my clients. Their business revolves around seeing people personally, and they're not able to see people personally, even if they're allowed to be open. Dentists right now are allowed to be open, but nobody's going. Mm-hmm. Restaurants that can be open, but nobody's sitting inside. And that fear, I think, as long as that fear is out there, we've got a potential issue that could go on for a long time, or it could end. It could be a vaccine, maybe Moderna or hopefully Gilead, or somebody is successful and we've got a vaccine in a month, and now the fear is all gone. So it's really something we need to keep an eye on, and you want to get ahead of it and figure out what type of negotiations and communication are available now, because everybody right now is, I think, dealing with periods of uncertainty. You have a duty, you always have a duty under every contract to mitigate your damages. So, again, if you're a restaurant and you don't do takeout, but you're allowed to be open and you have a lease, and if you don't want to pay your lease because you're going to say, well, I can't have people come in the restaurant, one of the issues that may get asked later is, what did you do to mitigate your damages? Or did you take advantage of opportunities to use third-party services or to deliver, where you offered opportunities to deliver and you didn't do it? Again, telehealth. If you had an opportunity to provide telehealth services, but you just didn't do it because you didn't want to get up to speed on the technology, it's pretty simple now. Or for some other reason, are you going to be able to get out just because your regular way of performing or whatever the contract calls for in a contract situation is unavailable? And understanding you're always going to have a duty to mitigate damages. And if you think you can't perform, notice. The court's always at, how soon did you give notice and let the other side know that you've got a potential issue? Now, notice is often strategic. So, of course, you may want to talk to your advisors on how to give notice, when to give notice, giving notice properly. If you have a written contract, almost every contract will have notice requirements, how you give notice. Follow those. People often ignore them. So notice, mitigation, of course, review your ability to continue to perform just in various ways. Supply chain, here's our note on communicating honestly, and how can the parties work together? Put yourself, that's just a negotiating point, really. Try not to make it us against them. Try and, when you're negotiating, everybody's in this together. And I have found most people, I've talked to a lot of attorneys and a lot of other folks since this all started. And it's been very, generally very positive and very promising, the way folks on the other side are looking at this like, gosh, we're all kind of, it's like a new world since the beginning of March. And so, what type, approach the communication from a standpoint of, we're all going through this together. How can we work to get out of it? And I think you have more success, especially if you have a long-term relationship already that you're trying to cope with, a long-term lease or some other type of obligation. We've got a couple minutes left. We can field a question. If we don't get a question, we'll probably roll off. I kind of took them as we got them as we were going. I'm not seeing anything on here. And just to conclude, here's our contact information. You can find us on the web at forsterbowman.com. My contact information at Skips. We do these webinars on a regular basis, so we hope you'll join us again. And I write a blog on health topics and health and technology. I just did one on these telehealth payment issues, so if you're interested in something like that, you can pop on there. Also did one recently. I did an article, and this should be popping up in Kiplinger's soon for credit facility workouts for professional advisors. So if you have issues where you're wondering what your options are in working with debts and obligations, from a business perspective and how that might impact you personally, you may want to check that out. Let me know. I can send you a link for that or put you onto it. And with that, I think we're at about 12:59, almost 1 o'clock. Skip?
I just want to remind people, we've also done a webinar recently on the PPP program.
Yes.
And people are raising questions now about enforceability. That's something that we're working through. And I want to thank you for joining us, and thank you, Eric. That was a lot of fun.
Great. And please, if you have questions, if there's something we didn't get to during the webinar or something pops up in your head, do not be afraid to call us. Our contact information is here. We're happy to field the call, and we wish you all a safe and happy rest of your day, week, and the rest of the time that we spend in COVID land. Bye-bye.